Welcome to the Connecticut Caselaw podcast. I'm Jay Ruane of Ruane DUI and Criminal Defense Attorneys. This week, we are covering decisions released on judicial ending the week of August 21st, 2026. Let us get into it. The next case is Alvarez versus Commissioner of Correction. This is a habeas corpus case involving a homicide in New Haven. Jorge Alvarez was convicted of murder following a 1988 shooting outside the Oasis Club. He was sentenced to life imprisonment, and his conviction was affirmed by the Supreme Court. This was his third habeas action, and it raised two main claims: ineffective assistance of habeas counsel and actual innocence. On the ineffective assistance side, Alvarez argued that his second habeas counsel, Attorney DeSantis, dropped the ball by failing to raise a claim that his criminal trial counsel, Attorney Altshuler, mishandled the questioning of a witness named Young. At trial, Altshuler started to ask Young whether he had ever told anyone that a person named Rashim was the shooter. The prosecutor objected, then withdrew the objection after an off-the-record discussion. And then Altshuler simply moved on and never asked the question. The theory was that Young had given an unsigned police statement indicating that another witness, Hazard, told him at the scene that someone named Rashim was the shooter, pointing to a different perpetrator. The habeas court rejected the claim, and the appellate court, in an opinion by Judge Elgo, joined by Judges Alvord and Pellegrino, agreed. The court applied the familiar Strickland two-prong standard and found that Alvarez could not get past either prong. On deficient performance, the court emphasized that Altshuler never testified at the habeas trial. Without knowing why he stopped that line of questioning, the court could not second-guess him. Altshuler may have made a deliberate tactical call, perhaps to avoid opening the door on redirect. Or he may have recognized that Young's statement contained hearsay within hearsay, making it likely inadmissible. That double-layer hearsay problem, Hazard telling Young what he saw, and Young's statement to police about what Hazard said, meant the statement likely was inadmissible unless each layer independently fit a hearsay exception. On prejudice, the court pointed out that Young testified at the habeas trial and said flatly that Hazard never made any statements to him about the shooter's identity. Young also said he had no recollection of giving a police statement at all, so there was no evidence of what Young would have said if Altshuler had pressed him at the criminal trial, and no evidence the statement would have been admitted. The actual innocence claim fared no better. The appellate court reaffirmed the rule it has consistently applied, that actual innocence claims must rest on newly discovered evidence. The court noted that the Supreme Court has not yet weighed in on whether that requirement is absolute, but this panel said it was bound by existing appellate court precedent. Alvarez tried to rely on McCrea's habeas testimony, Perry's habeas testimony, the unsigned Young police statement, and a 1988 police incident report. The court disposed of each. The police documents existed at the time of trial, so they are not newly discovered by definition. The McCrea and Perry affidavits were not admitted into evidence as full exhibits in this habeas case, so the habeas court properly ignored them. McCrea's live testimony was consistent with her recantation at the criminal trial, so nothing new there. And Perry, who invoked his Fifth Amendment right against self-incrimination in response to several questions, did not provide affirmative proof of innocence. Invoking the Fifth is not evidence that someone else committed the crime. The court dismissed the appeal, finding the habeas court did not abuse its discretion in denying certification. The practice takeaway here is straightforward and important. If you are habeas counsel and you intend to challenge trial counsel's handling of a witness, you need to call trial counsel to testify and pin down what the rationale was. In this case, because Altshuler never took the stand at the third habeas trial, the court had no basis to find deficient performance. The absence of that testimony gave the court every reason to assume a tactical decision was made. The failure to build that record is exactly the kind of gap that kills ineffective assistance claims at every level. The next case is Borsey v. Borsey, a post-dissolution family law appeal decided by Judges Alvord, Mall, and Wilson, with Judge Wilson concurring separately. John and Nicole Borsey divorced in 2012. Their dissolution judgment incorporated a separation agreement requiring John to pay $200 per week in child support, and the parties explicitly reserved jurisdiction for the court to later consider a post-majority educational support order. More than 10 years passed without any court filings. Then in early 2024, Nicole filed a motion to modify child support and sought an educational support order under General Statute Section 46B56C for the party's daughter, who was planning to attend Fordham University. The trial court, Judge Cooper, denied both requests. On the educational support issue, the court found it could not determine that the parties would have contributed to their daughter's college education if the family had remained intact, which is the statutory threshold under Section 46B56C, before a court can even consider the other factors. On the child support arrearage issue, the court assumed that Nicole had established a substantial change in circumstances, but credited John for years of voluntary overpayments, so no arrearage was ordered. The appellate court reversed on both issues. On the educational support question, Judge Alvord, writing for the majority, zeroed in on an internal contradiction in the trial court's own ruling. The trial court had expressly found, as an undisputed fact, that John agreed to give the party's daughter approximately $12,000 to help with her first year of college expenses. Both parties testified consistently on that point, but then the trial court turned around and found that the parties would not have contributed to her education if the family had remained intact. The appellate court said those two findings cannot coexist. If you found he agreed to give her $12,000 for college, you cannot simultaneously find that parents in an intact family would not have contributed. That threshold finding was clearly erroneous. The case goes back for the trial court to consider all 6 statutory factors under Section 46B56C on the existing record and decide whether to actually enter an educational support order. On the arrearage issue, the analysis is equally important for practitioners. After the 2012 dissolution, the parties privately agreed in 2016 that John would increase payments to $300 per week, an amount calculated under the child support guidelines. He paid that amount until 2019, then unilaterally reduced the payments. Nicole filed for modification in 2024. The appellate court construed the trial court's ruling as effectively finding that she was owed an arrearage for the 9 weeks between service of her motion and when child support terminated, but then crediting John for his prior voluntary overpayments and zeroing out the arrearage. The appellate court said that was an abuse of discretion. The prior payments were not a prepayment of future support. They were the amount the child was actually entitled to under the guidelines, paid by informal private agreement. Nicole never consented to those payments being treated as a credit against anything, and John's own 2016 email made clear he understood she retained the right to seek a formal modification. Crediting those prior payments was improper. The case was remanded with direction to order John to pay Nicole $753. The next case is Deutsche Bank National Trust Company v. Powell. This is a residential foreclosure case out of New Haven, and the core issue is whether a committee sale of mortgage property was void because it took place while an automatic appellate stay was in effect. Here is the background you need. The plaintiff, Deutsche Bank National Trust Company, as trustee, had been trying to foreclose on Gary Powell's Wallingford property since 2016. The judgment of foreclosure by sale came down in 2018, but the sale was reset an extraordinary 17 times over the following years due to the pandemic, multiple bankruptcy filings, and a series of appeals. When the trial court rescheduled the sale yet again in February 2025, Powell appealed, triggering an automatic stay under Practice Book Section 6111A. This court dismissed that appeal as frivolous in March 2025, but Powell then timely petitioned the Supreme Court for certification to appeal. Under Practice Book Section 84-3A, That petition kept the stay alive. The Supreme Court did not act on the petition until April 30th, 2025. The committee sale went forward anyway on April 12, 2025, while the petition was still pending. The trial court, Judge Stone, later approved the committee sale and deed. Powell objected, arguing the sale happened during an active stay and was therefore void. The plaintiff countered that any error was harmless because by the time the court approved the sale, the Supreme Court had already denied certification and no stay remained in effect. Judges Maul, Westbrook, and Wilson reversed. The court held that the sale was void ab initio. The reasoning is straightforward. Practice Book Section 61-11A is mandatory by its plain language. Once Powell filed a timely petition for certification, Section 84-3A extended the stay until the Supreme Court acted. Because the Supreme Court did not deny certification until April 30th, the stay was unquestionably in place on April 12th when the sale occurred. The court also rejected the harmless error argument directly. Relying on First Connecticut Capital, LLC v. Homes of Westport, LLC, the panel reaffirmed that a foreclosure sale conducted in violation of an appellate stay cannot be salvaged by pointing to equitable powers or arguing no prejudice resulted. The stay provision is mandatory, the committee has no authority to sell during a stay, and the court as vendor cannot ratify what was already a legal nullity. The order approving the sale was reversed and the case was remanded with direction to vacate the sale entirely. The practice takeaway here is direct. If you represent a plaintiff in a foreclosure by sale and your borrower has filed a petition for certification to the Supreme Court, stop. Do not proceed with the sale. The automatic stay under Section 84-3A is not discretionary and there is no harmless error escape hatch. Confirm the petition has been formally denied before you allow the committee to act. A sale conducted even one day too early is void, and you will be starting over regardless of how long the litigation has already taken. The Connecticut Caselaw podcast is brought to you by Ruane DUI and Criminal Defense Attorneys, Connecticut's statewide criminal defense firm. We gladly accept referrals of criminal and DUI defense cases throughout Connecticut. In Fairfield and New Haven counties, call 203-925-9200. In Hartford County and Eastern Connecticut, call 860-925-9200. Always available online at ruaneattorneys.com. Now back to this week's decisions. The next case is Greenspan versus Greenspan, a family law case decided by Judges Clark, Westbrook, and Wilson. Howard Greenspan moved to reopen his divorce judgment, claiming his ex-wife Carrie fraudulently concealed an ownership interest in a company called Greenbella Consulting, incorporated during their dissolution proceedings. He wanted the judgment open for the limited purpose of conducting discovery. The trial court held a preliminary probable cause hearing under the framework established in Oneglia v. Oneglia, then denied the motion. Howard appealed on 3 grounds: that the court applied the wrong standard of proof, that his circumstantial evidence was enough to clear the probable cause bar, and that the court improperly let Carrie off the hook without requiring her to substantiate her defenses. The appellate court affirmed on all 3 grounds. On the standard of proof, Howard argued the trial court's language about no credible or persuasive evidence signaled it had quietly applied something closer to clear and convincing evidence rather than the probable cause standard. The appellate court disagreed. Reading the memorandum of decision as a whole, the court found it expressly cited the probable cause standard, identified the right governing precedent, and analyzed the evidence in a way fully consistent with that standard. The court also noted that under Oneglia, the trial court is specifically permitted to weigh evidence and assess witness credibility at a preliminary hearing. That is not a sign of a heightened standard. That is just what the probable cause inquiry requires. On the sufficiency of the evidence, the key documents Howard submitted were Greenbella Consulting biennial statements from 2009 and 2011. The 2009 statement listed Carey as CEO and included her alleged signature as president. The 2011 statement listed her sister as the new CEO and noted Carey as the prior CEO. That was essentially it. No documents connected Carey to the other companies Howard pointed to. And critically, both biennial statements predated the 2016 dissolution complaint by several years. Being listed as CEO of a company in 2009 does not establish probable cause that you held an ownership interest requiring disclosure in a case that started in 2016. The rest of Howard's case rested on his personal belief that his late father-in-law would not have favored one daughter over another, and his theory that the company names blended family names together. The appellate court held that circumstantial evidence this speculative cannot move a fraud claim beyond mere suspicion. On the burden of proof question, the appellate court drew a clean distinction. Carey's testimony denying any ownership interest was not an affirmative defense requiring her to carry a burden. It was a denial of Howard's material allegations. The burden stayed on Howard the entire time, and he did not meet it. The central statute here is General Statute Section 52-212A, which generally limits motions to open judgments to 4 months after entry, with fraud as one recognized exception to that deadline. The practice takeaway is straightforward. If you are advising a client who suspects a former spouse hid assets during dissolution, stale corporate filings showing a title without proof of a continuing ownership interest during the relevant period will not get you past a probable cause hearing. You need evidence tying the alleged concealed interest to the time frame of the actual dissolution proceedings. Without that temporal connection, you are likely looking at a denied motion and an affirmed judgment on appeal. The next case is LSL LLCV, Kristen Lyons Revocable Trust. This is a real property dispute out of Madison, Connecticut, involving a claimed easement by implication over beachfront and barn access. The appellate court, in an opinion by Judge Westbrook joined by Judges Mall and Suarez, affirmed summary judgment for the plaintiffs and clarified an important point of Connecticut easement law that every real estate attorney in this state needs to know. Here's the setup. The Fogel property and the neighboring Carrabba property were once part of a larger unified parcel owned by the Hotchkiss family. When the parcels were eventually separated, the deeds did not grant or reserve the easements or rights of way the defendants claimed. The defendants, Catherine and Stephen Carrabba, claimed an implied easement over the Fogel property to reach a private beach called Mud Beach and to access the northern side of a barn on their own property. Their argument was that the Hotchkiss family had historically crossed what is now the Fogel property to reach Mud Beach, that access to the barn area also had historically been made by crossing the Fogel property, and that implied intent to continue that use should carry the day. The trial court initially denied summary judgment, reasoning that intent is the principal factor for an easement by implication, and that necessity is just one pathway to show intent. The plaintiffs moved to re-argue, pointing out that the court had relied on dicta from Cheshire Land Trust, LLC v. Casey, and that the dicta mistakenly drew from a map-based implied easement context that should not have governed this unity of title case. The trial court agreed, vacated its prior decision, and granted summary judgment for the plaintiffs. The defendants appealed. The appellate court affirmed on both issues. On the easement question, the court made this clear. When you are not relying on a recorded instrument like a subdivision map that expressly supports an easement, both elements of the implied easement test are required. That means you need to show the grantor intended to create the easement at the time of severance, and you need to show the easement is reasonably necessary for the use and normal enjoyment of the dominant estate. Both. The conjunctive matters. The court traced this back to Rishal versus Bachman and Utai versus GCS Realty, LLC, and distinguished the map-based cases like McBurney versus Cirillo, where necessity can be found through implication from the recorded instrument itself. On the facts, the defendants came up short on necessity. Their barn sits entirely on their own property and can be accessed from within their own parcel. For Mud Beach, they had access to a nearby public beach. Just as in Schultz versus Barker, convenience is not enough. The defendants never presented evidence that crossing the Fogel property was reasonably necessary in any meaningful sense, so summary judgment was appropriate. On the re-argument issue, the court held that the trial court acted within its discretion. The purpose of re-argument is to raise a principle of law with controlling effect that was overlooked or misapplied, and that is exactly what happened here. The court had built its original ruling on a footnote that was dicta in a factually inapplicable case. Correcting that was a proper use of re-argument, not a second bite at the apple. The practice takeaway is this: if you represent a party claiming an easement by implication and you cannot point to a recorded instrument that supports it, do not assume intent alone will carry you through. You need evidence of reasonable necessity, meaning the dominant estate cannot be used and enjoyed without the easement and there is no reasonable alternative at reasonable cost. Build that record early. If you're on the other side defending against such a claim, focus your summary judgment motion on necessity first. If the claimant has any alternative access, even a public beach or their own interior lot access, that may be enough to defeat the claim as a matter of law. The next case is State versus Bennett. This is a criminal case, and it raises a jurisdictional question that comes up more than you might expect in post-conviction practice. Eric Bennett was convicted of murder after stabbing a man outside a bar in Meriden. He was sentenced to 50 years. The Connecticut Supreme Court affirmed his conviction in 2017. He then pursued habeas litigation, which also did not go his way. In January 2024, more than 12 years into his sentence, Bennett filed a motion in the original criminal docket to open and vacate his conviction on the ground that it was procured by fraud. He raised a long list of allegations, including illegal searches, perjured testimony, withheld exculpatory evidence, and various conflicts of interest. The trial court, Judge Harmon, denied the motion, noting that the court lacked subject matter jurisdiction because Bennett had already been sentenced and was serving his time. Bennett appealed, arguing that just as Connecticut courts can open a civil judgment obtained by fraud at any time, the same common law exception should apply in the criminal context. The appellate court, in an opinion by Judge Westbrook joined by Judges Wilson and Keller, disagreed. The court reaffirmed the well-settled rule that once a criminal defendant begins serving his sentence, the trial court loses subject matter jurisdiction. That principle goes back to the common law, and it has been consistently applied by the Supreme Court, including in State versus Butler. The way to get around it is through a recognized exception, such as an unambiguous legislative or constitutional exception. The court declined to create a new common law fraud exception for several reasons. First, the civil fraud exception to General Statutes Section 52-212 does not actually implicate jurisdiction because civil courts retain continuing jurisdiction after judgment. Criminal courts do not, so the analogy does not hold. Second, criminal defendants already have expansive remedies available to raise fraud-based claims, including a petition for a new trial under General Statutes Section 52-582, which allows 3 years, and habeas corpus, which is designed to address convictions that violate fundamental fairness. The court also noted that even if it were willing to consider recognizing such an exception someday, Bennett's case was not the right vehicle. His motion did not raise any newly discovered evidence supporting a colorable fraud claim that could not have been surfaced earlier. It largely rehashed arguments that had already been litigated multiple times under different legal theories. One wrinkle worth noting, the trial court denied the motion. The appellate court said that was the wrong disposition. Because the court lacked subject matter jurisdiction, it had no authority to reach the merits at all. The proper form of judgment was dismissal, not denial. The case was remanded with direction to dismiss. The practice takeaway here is straightforward. If you are advising a client who is already serving a criminal sentence and wants to challenge the conviction through a motion filed in the original criminal docket, understand that the trial court almost certainly lacks jurisdiction to entertain it. The proper vehicles are a petition for a new trial under Section 52582 within 3 years of judgment, or a habeas corpus action. Framing the challenge as fraud on the court will not by itself create jurisdiction where none exists. And if you are on the other side and the trial court denies rather than dismisses for lack of jurisdiction, note that the form of the judgment matters on appeal. The next case is State v. Thompson. This one involves a motion to correct an illegal sentence, and the appellate court affirmed the trial court's denial on both grounds raised. Earl Thompson was convicted back in 2009 of conspiracy to commit robbery in the first degree, robbery in the first degree, and kidnapping in the first degree as an accessory, and received a total effective sentence of 45 years. Years later, he filed a motion to correct an illegal sentence, raising two claims. First, that the sentencing court relied on materially false information, and second, that his sentence violated double jeopardy. On the false information claim, here is where it gets interesting from a preservation standpoint. At the trial court level, Thompson argued he had never actually been convicted of violating a protective order at all, even though the pre-sentence investigation report showed two such convictions. The trial court rejected that, finding no evidence the PSI was wrong. Then on appeal, Thompson shifted his argument entirely, claiming for the first time that the sentencing court misstated the number of convictions, saying 4 when the PSI showed 2. The appellate court, in an opinion by Judge Maul joined by Judges Suarez and Westbrook, declined to review that reframed claim because it was never presented to the trial court. The court also declined to extend Golding review, noting that a motion to correct an illegal sentence can be filed at any time, so Thompson has an available remedy below. On the double jeopardy claim, Thompson conceded that conspiracy to commit robbery in the first degree and robbery in the first degree are separate and distinct offenses under a Blockberger analysis because each contains a statutory element, the other does not. His argument instead was that the way the state charged the robbery count, referencing the defendant and another participant, effectively folded the conspiracy into the robbery charge as a lesser included offense. The appellate court rejected that, relying on State v. Abraham and State v. Tinsley, which make clear that Blockberger analysis looks only at statutory elements, not at the facts alleged in the charging document. Because Thompson conceded the statutory elements point and did not argue any contrary legislative intent, his double jeopardy claim failed at step 2. The practice takeaway here is straightforward but important. If you are handling a motion to correct an illegal sentence and you have a false information at sentencing claim, make sure you identify and present every theory at the trial court level. The appellate court will not let you reframe the argument on appeal, and because these motions can be refiled, the court has no reason to strain to reach an unpreserved claim. Lock in your specific factual and legal theory below, or you will be starting over. That is all for this week's Connecticut Caselaw podcast. New episodes every Friday. Subscribe wherever you listen to podcasts. Give us a 5-star review, and we will see you next week. This podcast is for informational purposes only and does not constitute legal advice. This episode was written and voiced using artificial intelligence. Please read the full opinions yourself before relying on anything discussed here.